Hello friends, welcome to Kautilya Academy Jabalpur's YouTube channel. Myself Abhishek Singh. Friends, today we are going to discuss a very important topic that is written here, judicial activism. See, very often we keep hearing about the various Supreme Court judgments, especially nowadays we are listening about the judgments related to the serious air pollution problems in Delhi. So at times we wonder whether the Supreme Court has got the responsibility to order the executive officials or whether to legislate, or is it a type of exaggeration of the power that Supreme Court is going to exercise. So the topic is all about that, right? Here the present context is about the recent orders of the Supreme Court related to the air pollution in Delhi as well as the various other judgments. For example, recently we saw the implementation of the NRC in Assam, as well as we also witnessed the triple talaq verdict, that was the case of Shaira Banu in 2017, right? So here the judicial activism is going to be a very important topic for all of you with respect to the exams conducted by both UPSC as well as the MPPSC. Fine. So let us see that first of all, what is judicial activism? A judicial activism may be a progressive philosophy or a constitutional conflict, right? But not all of the scholars agree to these points. Some of us also call it as the judicial overreach, while others name it as the inactivity or say the underreach of the executive or the legislature of the country. So what is it exactly? Is it a simple philosophy or it is a progressive philosophy? But the scholars define it the progressive philosophy where the judges seem to actually move ahead, move out of the conventional precedents of the constitution, and they interpret the verdicts, they interpret the situations according to their own wisdom, and therefore the innovative judgments come out of the conventional constitutional contexts, and this is what we call as the judicial activism. Fine. So see, for example, if we take a simple case that the right to life, I think we all might have heard about this, that earlier the right to life was considered a very simple constitutional right interpreted by the Supreme Court in the famous A.K. Gopalan case, whereas in the later years, in the famous case of Menaka versus Union of India, the Supreme Court interpreted the right to life as an entirely new thing. That is a very wide scope of the Article 21 was interpreted. So that is we can put under the example of the judicial activism. All right. So moving further, that where did it come from? Fine. So what are the sources? Means judicial activism, has it come from somewhere outside, some other constitutional practices, for example say USA or the United Kingdom, etc., or has it come from our very own constitution? Friends, here we can see the various sources in the constitution itself which are given, and also the innovations such as the PIL. Fine. So let us discuss all these one by one. First of all, Article 142. How does Article 142 provide the scope for the judicial activism? So Article 142 provides the scope that the Supreme Court, in order to give its verdicts, may interpret the situations, may interpret the constitution or the conditions according to its own understanding of the situation, according to its own verdict, according to its own interpretation. So here any justice can take the you can say use of this provision in order to pass on a progressive judgment on a particular issue. Similarly, Article 32, Article 226, these are very famous articles. Here Article 32 provide the scope of the constitutional remedies for the Supreme Court, and this provides for the High Court. Fine. So these two articles also provide a great scope to both Supreme Court as well as the High Court to bring out certain innovative legislations, or say we will not call them as legislations, but those will be a type of pseudo legislations, because see, the lawmaking is basically the work of legislature, that is very well known. But when the Supreme Court lays down a particular verdict that comes equivalent to the lawmaking, that is we call as the pseudo legislation. And then comes the PIL. So what are the PILs? I think all of us might have heard about it. The public interest litigation, the very famous, you can say, the concept which actually came in the forefront in 1980s. Fine, I think you might have heard about Justice E. Ahmedi and well. So PILs are basically the public interest litigations through which the Supreme Court has given various verdicts. In fact, you can say the verdicts such as the restriction of the use of leaded petrol in Delhi. That was one of the famous examples which was granted in 1992. And again in 1995, the Supreme Court gave its very famous verdict where it actually tried to force the government to implement the right to information, which was declared as the basic part of the right to information. Right. Again, we see the Supreme Court actually doing a lot of legislative works, a lot of actually pseudo legislative works. So, is there any strict separation of power between the Supreme Court and the other two bodies, other two pillars of the democracy? I think we would be very much aware that there are three pillars of democracy. Fine. Which are they? They are the judiciary, the executive and the legislature. While the executive and legislature are somewhat, you can say depending upon each other, but the judiciary has been kept absolutely different from both of these, absolutely separate. So, which are the provisions in our constitution which provide the separation of the power between these bodies? So, let us examine each of them one by one. The Article 50, you all might be aware that Article 50 is the part of the directive principles of the state policy, right, which actually declares that there should be the separation of executive as well as the judiciary. And after that, Article 105 clause 2 and Article 194 clause 2. These two articles immune the legislators, the members of the union legislature and the state legislature from any type of judicial inquiries for their conduct or for their discussions, for their verdicts in the house during the process is going on, during the procedure is going on. After that, we have got Article 121 and 122, which these two articles put restrictions upon the Parliament and upon the court to interfere in the works of each other. And similarly, the Article 211 and 212, these two articles are applicable for the state legislatures. Fine. So, we have got great provisions in our constitution which actually provide the separation of power between the executive, legislature and the judiciary. But see, having got these separation, how does the Supreme Court then actually enters into the scenario? How does the Supreme Court becomes so potent to overturn the orders of the legislature, overturn the orders of the executive? There are certain reasons. The question says that why did it come to use? The very big question arises to the mind that if there are strict separations, so why did the Supreme Court come using this power of the judicial activism? So there are certain reasons. First of all, the Supreme Court, it is the guardian of the constitution. All right. Supreme Court is stated to be the guardian of the constitution. So whenever the Supreme Court thinks or Supreme Court finds that there is a probable violation of the constitution, the Supreme Court comes up with the certain corrective measures, certain remedies to restore the constitution in its own order. We can take the example. For example, see there has been a huge huge array of the cases, especially related to the right to property. We can name a number of cases related to that. For example, beginning with the Bela Banerjee case in the 1954 and going up to the Minerva Mills case of 1980. So, number of cases are there where the Supreme Court has acted as the guardian of the constitution. Especially we can also name the SR Bombay case in 1994 there also. And then the second reason is the power of the judicial review. Fine. Supreme Court, though it is prevented by Article 122 to intervene while the legislation is going on in the Parliament, still the Supreme Court is actually given the power to review any type of legislation which has been passed by the Parliament. Fine. So the Supreme Court has got the scope to look after the pros and cons, look after the positives and negatives of any legislation, and to delete it or to keep it as it is. Fine, we can take the example here of the National Judicial Appointment Commission. That was a great case, in fact passed by the Parliament in 2015, but in the very same year it was annulled by the Supreme Court as well. Now the third is the constitutional remedies. Constitutional remedies are basically the solutions or the guarantee for the fundamental rights which are provided to the citizens of India in Article 32 with respect to the Supreme Court, and in Article 226 with respect to the High Courts. So the Supreme Court has also got the power for the constitutional remedies. That means they can actually provide the solutions to the problem of the people if they are facing a violation of the fundamental rights. In that case also, the Supreme Court may come out with a certain new type of legislations. Then discretionary powers to the Supreme Court under Article 142. Now, this makes the picture very clear. The Supreme Court under Article 142 is empowered to bring in various innovations, to bring in the own discretionary powers in order to give a verdict, in order to get it implemented, and therefore we can see a lot of examples where the Supreme Court under this particular article comes up with the innovative solutions. Then suo motu power. Now this is something which acts as a panacea for the Supreme Court, especially where the political inactivity and the unwillingness comes into the picture. That means very often we come to see, for example, the recent environmental cases related to the Delhi government, or the famous Starlight Vedanta case in the Odisha that was related to mining, and the famous case in the Nilgiri corridors in the Tamil Nadu, Kerala, etc., as well as the cases related to the Kudankulam nuclear plant in the Tamil Nadu, right. So these are a few examples where, due to the political inactivity, the Supreme Court came up with the suo motu power. If we are going to discuss some recent cases, we can take the example of the very famous Unnao rape case very recently, where the Supreme Court took the cognizance of the matter and asked the government to act promptly on that matter. So these are a few reasons where the Supreme Court automatically comes into the picture. All right. Now the few famous examples we are going to discuss. All right. So apart from the examples which we discussed here, which are the other instances which actually were proven as the landmark for the journey of this judicial activism in our country? So we would be discussing those cases, very famous cases in fact, one by one. So let us discuss some famous examples of the judicial activism. The judicial activism as was in the earliest cases and as in the latest cases as well. Fine. So first of all, here are the earliest examples we can see. The Kharak Singh case in 1962, and that was related to the extension of the personal liberty, because the constitution, it has defined the personal liberty with restricted to the liberty over its own body, but this particular case extended it further. Golaknath case in 1967. See, the government was actually constantly amending the part 3 of the constitution with due to the reason of the right to property, but the Golaknath case in Supreme Court gave the verdict that the fundamental rights, these are actually the sacrosanct part of the constitution and hence not subjected to any type of the amendments further. The Keshavanand Bharati case in 1973, one of the most discussed and most famous cases of the Supreme Court's history, the Keshavanand Bharati case, it gave the very famous doctrine of the basic features of the constitution. Using this very case, the Supreme Court has actually given out the various verdicts and tried to restore the constitution's basic structure. Menaka case in 1978, the due process of law. See, our constitution had actually borrowed the rule of law, or say the procedure established by law, from the British Constitution. However, the American system, the due process of law, is actually inspired from the American Constitution, and that is not mentioned in our Constitution. However, the Supreme Court inherited it in its verdict in the famous Menaka case. S.P. Gupta case, that is the first judge's case, a very famous case, which was actually responsible for the introduction of the concept of PIL, which further became the bedrock for the various cases coming up to the judicial activism. Now discussing some of the latest cases, which are the famous MC Mehta case in 2018. I think you might have heard that the Supreme Court had banned the sale of BS4 engines, and that there was a huge noise in the market. So by the date of 30th March 2020, there would be no sale of BS4 engines, but only the BS6 Bharat Stage 6 engines will be in the market. Then the next case will be the Subhash Mahajan case in 2018 related to the anticipatory bail in SC/ST Act. Friends, you might be very much aware about the Prevention of Atrocities for the Scheduled Castes and Scheduled Tribes 1989 Act. In that case, the Supreme Court recently in 2018 had passed out a verdict where it was negated to reject the anticipatory bail to the accused. But Supreme Court itself reviewed this decision and restored the original provisions, which again refused the anticipatory bail to the accused in the particular SC/ST Act. Now the Rajesh Sharma case was there in 2017, a very famous case related to the misuse of IPC section 498A. So what is that actually? That is related to the domestic violence or the violence in the marital relations against the women, and that was very often misused. So Supreme Court passed a verdict against that. That was a work of the Parliament. Then Arun Gopal case in 2017, the Crackles Regulations. Friends, I think we all might be aware that the Supreme Court is very strict regarding the use of the crackers, and therefore the regulation of the time from 10 p.m. to 12 midnight, the crackers were actually permitted to be blown in that particular time only. So these were some certain latest cases. Now coming to the pros and the cons of the judicial activism. What are the advantages and what are the disadvantages of the judicial activism? So coming to this point, first of all, it promotes the checks and balances. The advantageous point is that it promotes, it actually restricts the Parliament to legislate, in interrupted manner, unregulated manner, because the people as well as the Parliament itself knows that there is Supreme Court to have a check on that. Then it fills the legal vacuum. So wherever the Parliament fails to legislate on the proper issues, there the Supreme Court comes as a savior. Then the complete justice. See, wherever there is a law existing in the land, sometimes it is not able to provide the complete justice. For example, see, we had the laws related to the rape or laws related to the child abuse particularly. In those cases, Supreme Court came out with verdicts which actually were sufficient to provide the complete justice. Then deeper insights on the sensitive issues. Fine. So what are the deeper insights? That means the issues related to the environmental problems, the issues which are related to, say, the pollution, the water scarcity in a country. So these are certain cases where the laws are not very stringent, laws are not very useful. The Supreme Court comes up with a brighter picture. Then coming to the points of concerns, the disadvantages. That is, the separation of power is hampered, as the Constitution clearly defines that the Supreme Court is having its own sphere and the legislature and the executive are having their own spheres, but still this concept of judicial activism, it blurs this separation of power. Then no external accountability, as we know that the Supreme Court judges are not accountable to the people, not accountable to the public. So therefore, whatever decisions they come up with, those decisions are actually not answerable to anyone in the country. Then no guarantee for the popular wishes. That means sometimes the court thinks that the verdict which they are passing, that may be very useful for the people, but that may not be the case all the time, because the people, that, for example, we can take the example of a ban on crackers. Then personal biases. See, friends, very often we see that court comes up with the cases which are actually given a particular verdict, and then the verdicts are reviewed, as we saw in this very case. So that can be said that the judges might have their own bias working for any type of verdict in any particular case. Fine. So having concluded these topics, let us discuss that what were the probable questions which actually came up with the examinations of both UPSC as well as the MPPSC. So here we have a question that was the part of the very first question in 2019 UPSC, which asked that Do you think the Constitution of India does not accept the principle of strict separation of power? Rather, it is based upon the principle of checks and balances. So friends, concluding this video lecture, as we came up across with several technical terms, for example, judicial activism, or for example, judicial review system, or the political inactivism. So, we shall be finding out the meanings of those terms in the next lectures. Till then, how did you like this lecture? Tell your opinion in the comment section, and like and subscribe the Kautilya Academy Jabalpur's channel, and thank you for watching. Thanks a lot.